In 2014, High Court Judge Cobus Miller delivered a judgment in favor of the use of EVMs for elections without a voter verifiable paper trail. South African Senior Counsel Jeremy Gauntlett argued on behalf of the plaintiffs that the former Minister of Rural and Urban Development, Charles Namolo, did not have the power to set aside Part 3 and 4 of Section 97 of the Electoral Act 5 of 2014, which gives provision of using electronic voting machines subject to the utilization of a verifiable paper trail for every vote cast by a voter.
Parliament framed the right to vote in terms that there could be electronic voting if the conditions were met. The minister took out the protection, or rather didn't gazette them, didn't put them in. Now what did that mean? Well, you've heard from our learned friends, they accept that, as does that important document at page 199, that first of all, for the ordinary person voting, you have protection when you push the button, the noises are happening, you know what it means, and the colors flashing. You see a protection for yourself. Ah yes, the machine has it right, I voted for X. That's the first protection. And the second protection you have is that you're not just relying on the software. Because the lesson from several countries around the world, as we all know from our phones and from everything else, is they go wrong. We also know some very unfortunate other things in relation to software and the conduct of elections. So our unequivocal answer to Justice Mainga is, number one, it doesn't matter what impression the minister was under. We would accept that he might have been under a mistaken impression. It doesn't help him. It doesn't help anybody. The point was whether he had the power to put in half of 97 and not the other half when the two are conjoined by a subject to. And you've heard no, with respect, convincing argument from the other side in relation to that proposition.
South African Senior Counsel William Mokhare, who represented the government and the ECN, also made reference to the 2014 High Court judgment in his argument, further adding that according to Section 115 of the Electoral Act 5 of 2014, no election may be set aside by any competent court by reason of any mistake or non-compliance with this part.
So they're saying that there was non-compliance with Part 5, and if there is non-compliance with Part 5, then Section 115 does not come in because the elections were unlawful. But then they're clearly wrong on the clear reading of Section 115, because Section 115 says no election may be set aside by any competent court by reason of any mistake or non-compliance with this part. So it means that even the non-compliance with Part 5, it must still be material to vitiate the elections, because then Section 115 is there to protect the elections, and here we know that we're only dealing with non-compliance with a provision that was never put into operation, and with a provision which the court has already ruled on, with a provision which we know that on the basis of eau de grâce then has remained as a valid and lawful provision. So we submit that even if the court were to give the applicants the benefit of the doubt in respect of those 7 polling stations, 4 of which do not, or 3 of which do not even mention which of the machines bidded, whether it was presidential or National Assembly, then they're left with really nothing because of the provisions of Section 115 of the Electoral Act.
Chief Justice Peter Shivute concluded that the judgment by counsels will be looked at and that judgment on the case will be delivered on the 6th of February this year.